And FBI Director Kash Patel is about to face some tough questions when he testifies this week on Capitol Hill after some mistakes in his handling of Charlie Kirk's assassination investigation. Conservative activist Chris Rufo posted this. It's time for Republicans to assess whether Patel is the right man to run the FBI, adding that he performed terribly in the last few days. So Patel prematurely announced the suspect was in custody. He also appeared to take credit for the FBI's release of images that ultimately led to the suspect's arrest. Here's how Utah Governor Spencer Cox sees it.
This was a co-lead operation. So the FBI was co-lead with the state. We worked very closely together. I think Director Patel would tell you it was flawless. It was everybody just trying to decide, is this a good idea? The reasons to release it, I think, are pretty obvious, right? It makes it easier for lots of people to see it and maybe find someone.
Hey friends, Adam is here. A federal judge threatened to handcuff the sitting FBI director, Kash Patel, in open court for criminal contempt if he didn't hand over subpoenaed documents by the deadline. Then the judge went further, calling Patel's excuses about secret court orders not just weak, but baseless, and suggesting they may amount to perjury.
Mr. Patel, before you joined the FBI, you had very strong opinions about what the FBI was hiding regarding Jeffrey Epstein. In a September 2023 interview with Glenn Beck, you said the Black Book is under the, quote, direct control of the director of the FBI. In December 2023, you said, let us know who the pedophiles are. Even for a short time after becoming FBI director, in February of 2025, you tweeted, quote, there will be no cover-ups, no missing documents, no stone left unturned. In June, you told Joe Rogan, quote, we've reviewed all the information. We're going to give you every single thing we have and can. But then suddenly in July, everything changed. You and Attorney General Pam Bondi released one video and said that there was nothing more to see. Your July memo says you uncovered more than 300 gigabytes of data and physical evidence, but that you had decided no further disclosure would be appropriate or warranted. That is a quote. I think what happened, Mr. Patel, is that suddenly you discovered that Donald Trump's name was all over these files, and you started a giant cover-up.
The nation's top cop was just threatened with arrest by a federal judge, on the record, in front of everyone. Let that sink in. The man who runs the FBI, the agency that investigates perjury, is now being accused of it by a federal judge, in open court, with marshals standing by.
New exclusive MS Now reporting on FBI Director Kash Patel and a whistleblower's allegations about how he's using FBI planes. Joining us, MS Now senior investigative reporter Carol Lenig. So, Carol, what do you got?
A whistleblower has reported to the Senate Judiciary Committee Democratic ranking member Dick Durbin that FBI Director Kash Patel's use of his jet, the government jet, the FBI jet, has harmed actual investigations. Katie, I want to separate one thing, which is to say one of the allegations here is something that we at MS Now, my colleague Ken Delanian and I, have been reporting on for a while, working on this behind the scenes, and then the whistleblower comes forward to Congress and basically affirms a lot of our reporting, although there are new details here.
So here's the reality check the mainstream media won't frame clearly enough. Donald Trump's hand-picked FBI director is staring down the very real, very imminent threat of arrest, not a theoretical slap on the wrist, arrest, handcuffs, a holding cell. Because a judge demolished his legal smokescreens and made it crystal clear that stonewalling ends now, or Patel goes to jail.
The whistleblower says that in December of 2025, when there was a mass shooting at Brown University, Kash Patel was on his government FBI director jet in Florida, we are told, and that there was only one other available jet. But Patel had ordered it to be put on standby for another team. And that meant that during this mass shooting...
And here's the part that really matters. The judge didn't take anyone's word for it. He pulled up the official court docket. He went through it line by line, entry by entry, like an auditor looking for fraud. And you know what he found? Nothing. No sealed orders. No secret rulings. No hidden legal magic that would justify Patel's refusal to turn over a single document. That's a definitive finding. If a sealed order existed, it would be marked on that docket as sealed. If a secret ruling existed, there would be some trace of it. The judge found zero, which means Patel's entire excuse was fabricated. And a fabricated excuse to disobey a lawful subpoena? That's not a defense. That's contempt. Now let's go back a step, because this gets even uglier. Patel had previously sat before Congress, raised his right hand, sworn to tell the truth, and testified under oath that sealed court orders were preventing him from releasing those very same records. He said it with the full weight of his office behind him. Congress accepted that explanation initially, but now a federal judge has reviewed the actual record and said that claim is without merit and potentially perjurious. You don't hear judges use that kind of language lightly. When a judge suggests perjury, it means they see evidence of a lie, and lying under oath is a federal crime, 18 U.S.C. Section 1621. That's a felony, up to 5 years in prison, separate and apart from the contempt charge. So let's be honest about where Patel stands right now. He's not just fighting a subpoena, he's fighting two separate criminal exposures: criminal contempt for defying the court, and potential perjury for what he told Congress. And the judge made sure Patel understood the urgency. This warning wasn't delivered in a private chambers meeting. It happened in open court, with a public record, with spectators and reporters and marshals present. The judge told Patel directly, "Produce every document by the deadline, every single one, not partial, not redacted to death, or federal marshals will place you under arrest for criminal contempt and hold you until you comply." That's coercive incarceration. The kind where you sit in a cell, and the only key is your own compliance. You want out? Turn over the documents. You refuse? You stay. And here's the trap door Patel can't use to escape: an appeal. The judge stressed that any appeal will not pause the order. Patel cannot file a notice of appeal, go to the circuit court, and use that months-long process as a delay tactic. The judge made it explicit. Patel must comply while any appeal is pending, or he stays in jail during the entire appeal. That's a denial of an automatic stay. And without a stay, an appeal is just a piece of paper. It doesn't stop the marshals from showing up. This ruling doesn't just hurt Patel, it blows a massive hole in the long-running strategy he's used for months, hiding behind supposed court orders, technical objections, classification claims, and procedural smoke to dodge both congressional oversight and judicial authority. The judge saw through all of it, and now the shield is gone. But wait, because this story isn't just about one subpoena or one hearing. Patel is facing multiple fronts of pressure simultaneously. There are ethics complaints filed against him over his use of government aircraft for personal travel, allegations that he's been treating taxpayer-funded planes like his own private Uber, misuse of public funds, ethics violations. That's its own scandal. Then there's the new, almost unbelievable headline: his personal emails were hacked. According to reporting, Iranian intelligence allegedly gained access to those emails. Think about that. The sitting FBI director, the man responsible for protecting America from foreign espionage, had his personal communications compromised by a hostile foreign power. That's not just embarrassing. That's a national security failure of the highest order. It raises devastating questions about his cybersecurity practices, his judgment, and whether classified information was ever discussed on unsecured channels. So when you add all of it together, the contempt threat, the perjury suggestion, the ethics complaints, the foreign hack, you get a picture of an FBI director under siege. Legal pressure, political pressure, security pressure, all of it converging at once. And here's the deeper shockwave this sends through the system. A sitting FBI director is supposed to be the person who enforces the law. He oversees investigations into obstruction, into contempt, into perjury. He demands that everyday Americans comply with subpoenas. He tells witnesses that no one is above the law. But now that same man has been told in plain, unambiguous language that if he doesn't obey a court order, Federal marshals, law enforcement officers who ultimately work within the same Department of Justice, will arrest him. That means federal law enforcement arresting their own boss's boss. It's the system eating itself. And it completely undercuts Patel's moral authority to demand compliance from anyone else. How can you tell a grand jury witness to turn over documents when you're defying a subpoena yourself? How can you put others in handcuffs for contempt when you're one deadline away from wearing them? For the audience watching this unfold, the story is simple, dramatic, and almost cinematic in its irony. You have a man who oversees every federal investigation in America. He is now one court-imposed deadline away from being hauled into custody by his own agents because he kept defying a judge. The same judge went line by line through the court record, found no secret orders, called Patel's excuses false, and suggested he may have lied under oath. That's not spin. That's the record. So let's walk through exactly what the judge did and what it means. The judge reviewed the official court docket. That's the master list of every filing, every motion, every order, every transcript in the case. If a document is sealed, it still appears on that docket. It's just marked sealed with the contents hidden from the public. But the judge has full access to everything, including sealed materials. So when Patel claimed that sealed court orders were blocking him from releasing the subpoenaed documents, the judge had a straightforward way to verify that claim. Look at the docket. And he did. Systematically. Line by line. That's not a cursory glance. That's a meticulous forensic review. And the judge found nothing. No sealed orders that would justify Patel's refusal. No secret rulings that would excuse non-compliance. Now, secret rulings are an entirely different category. They would be orders never entered onto the docket at all. But those are extraordinarily rare because they violate basic principles of court transparency. Judges strongly disfavor them. For Patel to suggest that secret rulings existed without any evidence, without any notation, without any procedural trail, was always implausible. The judge confirmed they don't exist. That's a definitive finding. And it matters because Patel's entire defense rested on these supposed orders. He told Congress under oath that he couldn't comply because of them. Congress initially accepted that. But the judge's investigation has now proven that explanation was false. So Patel is either mistaken or lying. Given that he's the FBI director, someone with access to lawyers, staff, court records, and every resource necessary to verify his own claims, being mistaken is almost impossible to believe, which leaves lying as the far more likely explanation. And that brings us back to perjury. Congressional testimony is a formal proceeding. Witnesses swear an oath. That oath makes false statements a crime. Perjury requires three things. The statement must be material, it must be false, and it must be made knowingly. Materiality is easy here. Congress was investigating whether Patel was properly handling records and responding to oversight. His claim about sealed orders went directly to the heart of that inquiry. So materiality is established, falsity is now proven. The judge reviewed the docket and found no sealed orders. Patel said they existed. They don't. That's false. Knowingly is the only real question. But as FBI director, Patel has access to court records. He could have verified whether those orders existed before he testified. If he claimed they existed without checking, that's reckless disregard for the truth, and reckless disregard can satisfy the knowledge requirement for perjury. If he knew they didn't exist and claimed they did anyway, that's even clearer. Either way, a perjury case is strong. And when a judge says a claim is potentially perjurious, that's a signal. Judges don't use that word casually. It means the judge believes the evidence could support a criminal referral, and the judge could refer the matter to federal prosecutors, who could then charge Patel separately from any contempt proceeding. Now let's distinguish between the two types of contempt because that matters for what happens next. Civil contempt is coercive. Its purpose is to force compliance with a court order. The sanction continues until the person complies. The defendant holds the keys to the cell, meaning they can end their detention at any time by simply obeying the order. Civil contempt is not a crime. It doesn't require criminal trial protections. Criminal contempt is punitive. Its purpose is to punish past disobedience. The sanction is fixed. You can't avoid it by later complying. Criminal contempt is a crime, which means it requires proof beyond a reasonable doubt and gives the defendant trial rights, like the presumption of innocence and the right to counsel. The judge in this case threatened Patel with criminal contempt. That's serious. It means the judge views Patel's non-compliance not just as something to be coerced out of him, but as something deserving punishment. And criminal contempt can result in imprisonment separate from any coercive detention. A combination of criminal and civil contempt could mean extended incarceration. Patel could be jailed both as a punishment for what he's already done and as a tool to force future compliance. So, who exactly is going to arrest him? The U.S. Marshals Service. The Marshal Service is the oldest federal law enforcement agency in the country, founded in 1789. Marshals serve federal courts. They execute arrest warrants. They transport federal prisoners. They provide courthouse security and protect federal judges. Marshals arresting a sitting FBI director would be unprecedented. The FBI is also federal law enforcement. The FBI director is senior to the marshals in the traditional law enforcement hierarchy. But marshals serve the court, not the FBI. When a court orders an arrest, marshals must execute it. That creates a surreal situation where marshals are arresting their boss's boss. It shows how seriously the judge is taking enforcement. And the hold him until he complies language means coercive detention. Patel would be jailed, and that detention would continue indefinitely until he produces the documents. That creates powerful pressure to comply. But if Patel were physically unable to comply, if the documents truly didn't exist, detention could last a very long time, which is why civil contempt can sometimes be controversial. But here, Patel is clearly able to comply. He has access to the documents. He's choosing not to produce them. So coercive detention is entirely appropriate. Now, what about the denial of a stay pending appeal? When a court issues an order, the losing party can appeal. During that appeal, the losing party often asks for a stay, a pause on the order while the appeal is pending. Without a stay, the order takes effect immediately. If the order is later reversed, harm from immediate enforcement might be irreversible. Judges consider several factors when deciding whether to grant a stay: likelihood of success on appeal, irreparable harm if the stay is denied, harm to other parties if the stay is granted, and the public interest. Here, the judge didn't just deny a stay, he made clear he would not grant one. That means the judge believes Patel is unlikely to succeed on appeal, that compliance with the subpoena won't cause irreparable harm, and that the public interest favors immediate compliance. The practical effect is that Patel must comply now. He can't wait for an appeal process that takes months or years. If he could wait, the subpoena would be meaningless. The judge's denial of a stay shows he understands that. Let's zoom out and look at the pattern. The judge called this a long-running strategy. That's important. Patel hasn't just refused this one subpoena. He has consistently refused to comply with multiple congressional committees: the House Judiciary Committee, the Oversight Committee, the Intelligence Committee. His excuses have varied: classification concerns, executive privilege, ongoing investigations, and now sealed court orders. Each excuse sounded plausible at first, but upon examination, each one proved hollow. The pattern shows systematic obstruction. It's not an unfortunate side effect. It's the strategy. And the judge's word choice, supposed orders, reveals skepticism. Supposed indicates disbelief. The judge thinks Patel fabricated the excuse. Fabricating an excuse to avoid a legal obligation is contempt. Doing it under oath is also perjury. Both are crimes. An FBI director committing crimes to avoid oversight is staggering. Now layer in the ethics complaints. Campaign Legal and other watchdog groups have filed complaints about Patel's use of government aircraft. Federal regulations strictly restrict personal use of government planes. Officials can't use them for vacations or personal business. Exceptions exist for security reasons. An FBI director might need secure transport, but personal trips don't qualify. The complaints allege Patel used government planes for personal travel. If proven, that's misuse of public funds. Government aircraft cost thousands of dollars per hour to operate. Taxpayers pay those costs. Using them for personal benefit is theft of public resources. Ethics violations can result in fines, reimbursement requirements, or removal from office. The timing of these complaints is significant. They're being filed while Patel is already facing contempt and perjury exposure. Multiple scandals simultaneously compound political damage. They create a narrative of an official abusing his position, a narrative that undermines his legitimacy. And then there's the Iran-linked email hack. According to reporting from Al Jazeera and other outlets, Iranian intelligence allegedly gained access to Patel's personal emails. Think about that. The FBI director, the person responsible for protecting America from foreign intelligence threats, had his own communications compromised by a hostile foreign power. Personal email accounts are security risks for senior officials. They often contain sensitive information. Classified information should never be in personal email, but officials sometimes improperly use personal accounts for government business. If Patel discussed FBI matters in personal email, Iran may now have that information. That's an intelligence windfall for Iran. It compromises ongoing investigations. It endangers sources and methods. An FBI director being hacked by hostile foreign intelligence is a catastrophic security failure. It also raises devastating questions about Patel's judgment. Senior intelligence officials should use secure communications. Personal email accounts are vulnerable to hacking. Using them for sensitive discussions shows reckless disregard for security. And recklessness in an FBI director is disqualifying. So here's where we are. A federal judge has reviewed the docket line by line and found no sealed orders. Patel's excuse is false. The judge has suggested perjury. The judge has threatened criminal contempt with arrest by federal marshals. The judge has denied any stay pending appeal. Patel must comply by the deadline or face handcuffs. At the same time, Patel is facing ethics complaints over personal use of government aircraft. He's facing a scandal over Iran-linked hacking of his personal emails. He's facing a Congress that no longer accepts his explanations, and he's facing a public that is watching to see if the nation's top law enforcement officer will be arrested by his own government for defying a court. This is not normal. This is not how any of this is supposed to work, but it's happening. What functioning justice system requires is equal enforcement. That means even the FBI director must comply with subpoenas. He can't fabricate excuses. He can't hide behind documents that don't exist. He can't lie under oath about sealed orders that a judge later proves are fiction. And when a judge catches him, sets a deadline, and threatens arrest, that judge is doing the job we expect courts to do. No one is truly above the law, not even the people supposed to enforce it. So what do you think? Will Patel actually comply before that deadline? Or will federal marshals have to walk into FBI headquarters and arrest their own director? Drop your prediction in the comments. And if you want to stay on top of this story as it develops, because it's moving fast and the mainstream media isn't giving you the full picture, smash that subscribe button and join our newsletter. We're tracking Patel's legal jeopardy on every front: contempt, perjury, ethics, national security. Don't fall behind, because here's the bottom line. A dramatic hearing. An FBI director warned directly by a federal judge. Hand over the documents by the deadline, or federal marshals take you into custody for criminal contempt. The judge tore apart every excuse, called them baseless, suggested perjury, made clear arrest is imminent if the stonewalling continues. The judge reviewed the docket line by line, found no sealed orders, found no secret rulings. Patel told Congress under oath that sealed orders prevented compliance. The judge said that claim was without merit and potentially perjurious. In open court, the judge warned, produce every document by the deadline, or marshals will arrest you for criminal contempt and hold you until you comply. The judge stressed that an appeal will not pause the order. Patel must comply while any appeal is pending, or he stays in jail. The ruling blows a hole in Patel's long-running strategy of hiding behind supposed orders and technical excuses to dodge oversight. Combined with ethics complaints over travel and the scandal over hacked personal emails, the arrest threat adds to a picture of an FBI director under intense legal and political pressure on multiple fronts. A sitting FBI director told in plain language that marshals will arrest him if he doesn't obey a subpoena. That sends a shockwave through the system. It undercuts his moral authority to enforce the law on others. And for the audience, the story is simple and dramatic. The man who oversees federal investigations is now one court deadline away from being hauled in by his own agents if he keeps defying the judge. That's accountability. That's the rule of law. And no one, not even the FBI director, gets to hide from it.